Equal treatment in the workplace is a civil right protected by federal and state laws. Sexual harassment is a type of discrimination that interferes with or eliminates equality and fair treatment. It is also a very costly type of incident to manage. One claim could result in an employer lawsuit, a personal lawsuit, and possibly a workers' compensation claim, all in one, making for a very expensive bill which can prohibit work activities, payroll increases, job benefits, or even number of jobs that are available within a business. When looking at the bigger picture, each claim can directly affect the pockets and the livelihoods of all employees. What is harassment? Harassment is any unwelcome verbal, written, or physical conduct that either degenerates or shows hostility or aversion towards a person on the basis of their group, class, or category to which they belong, that has the purpose or effect of creating an intimidating, hostile, or offensive work environment, it unreasonably interferes with an employee's work performance, or it affects the employee's employment opportunities or compensation. So then what is sexual harassment? Well, sexual harassment is a form of discrimination in the workplace, which includes advances, requests for favors, suggestive gestures or innuendos, and other conduct that is directed towards or used against an individual because of their gender. So what makes a funny, lewd joke or a whistle an illegal action? Boundaries. We all have them. What is considered funny or offensive is unique to everyone, but no one should be subject to a workplace of disrespect and discrimination. If any of this conduct, the jokes, the looks, the whistles, or otherwise, is considered unwelcome by the offended person, the boundary into harassment has been crossed. If the conduct is severe enough and interferes with one's work conditions, then a more serious problem exists. Let's talk about freedom of speech for a minute. Creating a harassment-free work environment does not limit, restrict, or take away one's right to free speech, thought, or personal preference. In fact, it protects this right on a large scale because all employees have a legal right to a safe and harassment-free workplace, which allows them to have their personal freedom to have their own opinions and lifestyles. This means equal opportunities and neutral territory for all. The employment laws we are about to explain address the conduct appropriateness, implications, direction, and interference with work conditions that may cause this right to be violated. This means that if your actions interfere with someone else and cross the boundary into harassment, there are consequences. According to Section 703 of Title VII, it is illegal for an employer to discriminate against any individual with respect to compensation, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Sexual harassment falls under sex discrimination. Discrimination is when there's treatment or even the consideration of making a distinction either in favor or against a person based on the group, class, or category to which they belong. The federal law protects against discrimination and prevents retaliation, or in other words, revenge for causing trouble. This could either be overt or covert acts of reprisal, interference, restraint, penalty, discrimination, intimidation, or harassment against an individual or group exercising their rights under the law. Under Title VII, the EEOC holds the authority to enforce the statute in Section 703, which states that unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment. This happens when either submission to such conduct is made explicitly or implicitly a term or condition of employment, or submission to or rejection of such conduct by an individual is used as the basis for employment decisions, or 3. Such conduct has the purpose or effect of unreasonably interfering with their work performance or creating an intimidating, hostile, or offensive work environment. Any change in work conditions, pay, or tasks assigned typically trigger a claim, but something as small as an offhand comment, gesture, or innuendo can also trigger a claim. The FEHA protects California employees from discrimination and harassment based on 15 categories, with 15 requirements. Similar to Title VII, race, color, religion, sex, and nationality are included. In addition, harassment based on gender and identity or expression thereof, sexual orientation, marital status, ancestry, disability, medical conditions, both new and pre-existing, genetic information, age, the use of medical leave, and the use of pregnancy leave are also illegal. The information in this training will help to equip you to identify, respond to, and prevent any one of these forms of harassment. The law requires employers and their representatives to 1. Take all reasonable steps to prevent harassment, including establishing prevention policies and procedures. 2. It prohibits employers from limiting or restricting the use of any language unless it is justified by business necessity. Then employees must be notified of the restriction and consequences for use. 3. The law requires that all employers provide information to each and every employee regarding the nature, illegality, and solutions for prevention and reporting of sexual harassment. 4. The law requires employers with 50 or more employees at any time to provide sexual harassment training to the supervisors every 2 years at a minimum. 5. Employers are required to reasonably accommodate an employee or applicant's religious beliefs or practices. 6. They are also required to reasonably accommodate employees and applicants with disabilities in order to enable them to perform the essential functions of the job. 7. The law requires the employer to allow employees and applicants to file complaints through the Department of Fair Employment and Housing and any other company reporting system. 8. The law specifically prohibits discrimination in hiring, promotions, assignments, termination, or any term, condition, or privilege of employment. 9. Employers are required to retain applications, personnel records, and employment referral records for a minimum of 2 years. 10. Employers must provide pregnancy, childbirth, or related medical leave for up to 4 months. 11. Employers are required to provide reasonable accommodations to an employee as directed by their medical provider in regards to pregnancy, childbirth, or related conditions. 12. Employers are required to allow eligible employees to take up to 12 weeks leave in a 12-month period for the birth of a child, adoption placement, serious personal health conditions, or care for a parent, spouse, or child with serious health conditions. This employment right is also required to be posted for employees. 13. The law requires employment agencies to serve all applicants equally, refusing discriminatory job orders, prohibiting making discriminatory pre-hire inquiries, or writing discriminatory job ads. 14. The law prohibits unions from discriminating with member admissions or job dispatches. 15. Finally, the law prohibits retaliating against any person who opposes, reports, or assists another person in opposing unlawful discrimination. Let's compare the two laws. California's Fair Employment and Housing Act is more strict and more comprehensive than federal guidelines, allowing for compensatory damages and punitive damages. That means financial awards, or in other words, big fines to the company, which do not get capped or limited, similar to claims under federal law, which imposes limits to the damages incurred. If a claim is processed and won, fines can be issued and financial remedies awarded for the following: hiring, front pay, back pay, promotion, reinstatement, cease and desist orders, expert witness fees, reasonable attorney fees and costs, punitive damages, and damages for emotional distress. California was the first state to mandate sexual harassment training to all companies with 50 or more employees at a time. Supervisors in a company with 50 or more employees must receive a minimum of 2 hours of sexual harassment training every 2 years, and records of their training must be maintained for an additional 2 years. This can either happen on an individual 2-year cycle or on a company-wide training year schedule. The Assembly Bill 1825 and the California Government Code Section 12950.1 outlines specific requirements for the training, its content, scope, and application. If your company is associated with a labor union, you may also be subject to the National Labor Relations Act under the Unfair Labor Practices in Section 8. The union may become involved in the process to offer support to the employee. Workers' compensation helps employees when there has been an injury or other work disability at the workplace, regardless of who is at fault. Sexual harassment can fall under this category. If someone were to touch, grab, make verbal threats of a sexual nature, or worse, if there were assaults or rape, now the claim is compensational for injury or mental distress. Beyond the consequences to the company, sexual harassment can be grounds for personal legal action. Findings that could invite a personal action include intentionally inflicting emotional distress, when the harasser had calculated or intentionally caused or otherwise disregarded the possibility of the incident causing emotional distress. Assault or battery, when a victim experienced unwelcome physical contact of either offensive or injuring manner. False imprisonment, if the incident causes the victim to be intentionally confined or prevented from escaping the situation without the victim's consent. More severe actions, such as sexual abuse, physical or sexual assault, or rape, can result in additional criminal charges for the individual involved. Who these laws apply to? Well, the laws apply to both male and female, direct and indirect supervisors, agents of the employer, such as subcontractors, stakeholders, or other representatives, coworkers, and even non-employees, such as passerbyers. Essentially, anyone affected by the offensive conduct can use and be protected by these laws. These laws are also presented as a minimum for compliance and protection of basic employment rights, but everyone is encouraged to implement additional programming or require other employees to participate in training to further reduce harassment as needed.